Well, howdy there, folks. James, politicalfriar.com, coming to you again. I got my lawyer hat on, so we're going to talk about a legal topic today. But before I do that, I'm just going to remind you up front to please hit like on this video and subscribe at the end if you like what you heard. All right, legal topic. Well, something popped through the news today that you're probably not going to hear about because, war and budget battles and all kinds of other things are going to dominate the coverage, Donald Trump's civil trial. But it caught my eye because it's the next development in a story that I've been following, and that is the Supreme Court's ethics. For the entire existence of the court, the Supreme Court hasn't thought that it was necessary to write down its own ethics rules. It always said it abided by them, but it never really had a concise statement of just exactly what those rules were, which, as the Supreme Court says in its little preamble to this document, is kind of normal. The common law had various ideas about the ethics for judges, and everybody kind of knew the rules. But boy, there's some power in writing them down, isn't there? And that is something that the Supreme Court has finally done. So, good job, Supreme Court, in writing down your own rules. Now, rules for judges have been written down for decades, centuries. They're not uncommon, but they didn't ever apply to the Supreme Court. And this became a bit of an issue with two incidences in the last year or two. The big one that we've already talked about was Clarence Thomas and the gifts that he received from billionaires and what that looks like, which is bad. The other one was a leak of a proposed opinion on Dobbs. That's something that really hadn't happened before. And there are little indications when reading through this that they've now decided how they ought to handle those sorts of leaks, because it's not really a crime to leak stuff from the Supreme Court, is it? There's no statute that says you can't do it. There's no classification of Supreme Court decisions, so they had to address that. So I'm going to go through the 5 canons that the court has agreed to bind themselves to with a couple of notes on the interesting additions and ways that this ought to work, and then maybe speculate a little bit about how this will affect the court going forward. But I do want to start with the idea that, hey, this is good news. In a day where you're going to look at all the news today and say, gosh, that's terrible, this is good news. So let's go through it. All right, the first canon is just a conclusory, almost self-referential statement of we're good people. It says, a justice should uphold the integrity and independence of the judiciary. And I'm just going to read you the entirety of the rest of it. It says, a justice of the Supreme Court of the United States should maintain and observe high standards for conduct in order to preserve the integrity and independence of the federal judiciary. That's it. I guess it's a good place to start, just at the basics. Act okay. All right, Canon 2. A justice should avoid impropriety and the appearance of impropriety in all activities. This is our Clarence Thomas canon. And there's lots of notes to it, but there are 2 bits of it that are particularly enlightening as to the court's thinking here. It's subsection B, outside influence. So it says that a justice should neither knowingly lend the prestige of the judicial office or advance the private interests of the justice or others, nor knowingly convey or permit others to convey the impression that they are in a special position of influence with the justice. That is about powerful people socializing with the judges and how that relationship ought to look. It's not about the existence of some kind of inappropriate influence. It's about the appearance of it. So that's the little shot there that says, hey, this is, we've decided good versus bad behavior is don't even appear to allow that outside influence to come up. There's also another little note here, which I thought would be fairly obvious, but I'm glad they wrote it down. It's subsection C, non-discriminatory membership. A justice should not hold membership in any organization that practices invidious discrimination on the basis of race, sex, religion, or national origin. Now, that's obviously aimed at the KKK. People who understand the history of the Supreme Court know that there were Supreme Court justices who were members of the Ku Klux Klan. So this is an old rule, but it's one that I wonder how it might start popping up, especially when you're talking about discrimination on the basis of sex. If sex starts having meanings around gender and sexual orientation, as the court has adopted in some opinions, such as Obergefell, that could say odd things for our prominently Catholic judges and the Catholic Church's approach to those issues. But that is no way a binding legal requirement. It just starts raising eyebrows about, I wonder if that's an ethics thing there. All right. Moving past that little aside, which was a bit of a rabbit hole that I went down, let's talk about Canon 3. Canon 3, justice should perform the duties of office fairly, impartially, and diligently. Of course. This is to do, though, with the Dobbs episode. So, under Canon 3, a judge and judge's staff should not disclose the secrets of the court, and that they have to hold their staff accountable. Here's the money lines. Quote, a justice should take appropriate action upon receipt of reliable information indicating the likelihood of misconduct by a court employee. There's only one person who can fire a Supreme Court clerk, and that's the judge who hired him. The other 8 can say, we want that guy out, and that other judge can say, pound sand. Well, now it's in the adopted ethics that they ought to fire him. See, there have been many reports out there. Sam Alito has even said it in public that they know exactly who leaked the Dobbs opinion before the court announced it. They know the person. It was almost certainly a clerk, and almost certainly the judge that hired that clerk refused to discipline that person. We don't know that clerk's name, but it is known. And it's a secret, and it's going to stay a secret for some of the same reasons that the court has adopted this code of conduct, and that it would harm the prestige of the court to out that person. But the code of conduct now says that judges should fire anyone who is caught leaking. And now it's a rule. And you know it's a rule because it's written down. The next money line here is a justice should not direct court personnel to engage in conduct on the justice's behalf or as the justice's representative when that conduct would contravene the canons if undertaken by the justice. So that says we are incorporating all of the court personnel, and if you think that you can avoid the strictures of these canons, Mr. Supreme Court Justice, by having your staff do it, no. We're agreeing that that is just as unethical. So, Canon 4. Now we're in the next part of the Clarence Thomas discussion. Canon 4. A justice may engage in extrajudicial activities that are consistent with the obligations of the judicial office. Makes sense. You can give talks at law schools. You can even teach classes at law schools and get paid for it. You can do a lot of stuff that justices traditionally do. Here's the important provision inside of this canon, though. It comes in D3. So Canon 4, subsection D, subsection 3. Let's bury the lead if we possibly can. Here it is. A justice should comply with the restrictions on acceptance of gifts and the prohibition on solicitation of gifts set forth in the Judicial Conference Regulations on Gifts now in effect. That incorporates another set of ethics rules, ones that apply to every other federal judge, and that's the Judicial Conference Regulations on Gifts. It's another 8-page document that is incorporated by reference, and it lays out what gifts judges can and can't accept and how they ought to report them. So you've got this reference to the appropriate way to accept gifts, but it's a direct shot at Clarence Thomas's behavior. So let's take a look at the Judicial Conference's regulations on gifts now in effect and see how that might apply to the things that we know about Justice Thomas. So here's the base rule that's in that Judicial Conference on gifts. No gift may be accepted by a judicial officer or employee if a reasonable person would believe that it was offered in return for being influenced in the performance of an official act or in violation of any statute or regulation, nor may any judicial officer or employee accept gifts from the same or different persons on the basis so frequently that a reasonable person would believe that the public office is being used for private gain. So we have a couple of interesting things there. First, we're further incorporating the statutes and regulations about accepting bribes as federal employees, and we are explicitly talking about repeated gifts, saying that you cannot use the fact that you're a Supreme Court justice to enrich yourself personally, which is something that Clarence Thomas arguably did when he accepted all of those gifts. It's certainly something that he did when he accepted his mother's ability to stay in a house rent free. Those are fiduciary and benefits that would not have come Clarence Thomas's way but for him being a Supreme Court justice. And now the Supreme Court, including Clarence Thomas's signature, has said that that sort of thing is probably inappropriate. Well, that's news. Interesting. Finally, in Canon 4, we have a adoption of something that the Supreme Court justices have always done around reporting, but they're reaffirming it. So in subsection H, compensation, reimbursement, and financial reporting, here we have a commitment. So judges have agreed to comply with the statute governing financial disclosure, and the undersigned members of the court have each individually reaffirmed that commitment. So this is something that Clarence Thomas just didn't do. He didn't comply with that statute strictly, and there's no remedy for it, but now we have it written down in the rules that he ought to do that, and probably going forward he probably will, as well as the other justices. I am not so naive to think that this was something that was confined to Clarence Thomas and not doing his paperwork. It probably was others too, but now we have it written down. And then finally, Canon 5, a justice should refrain from all political activity. Well, that's pretty clear. And there are examples and other provisions within it, but that's not really news, and there hasn't been any particular allegation that the justices directly have engaged in proper political activity. Obviously, the justices' families are not banned from political activity. That would be an issue with the First Amendment. So if you're looking for Jenny Thomas to quit her committees, well, that's not going to happen. Anyway, this run through has been longer than I wished it was, but the high points here really are good news. It means that the Supreme Court at least is going to talk about policing itself. There's obviously no remedies in this. There couldn't be. The only remedy for Supreme Court misbehavior is impeachment, and that's by design. These judges are not supposed to be afraid of consequences when they make unpopular rulings. That just is a feature. This is better than I expected, though, that the judges have at least signed their name to a set of rules that are written down and says we're going to behave like this. Good. Because if an impeachment were necessary, you better believe the first example of why is going to come straight out of these rules that they just agreed to. Anyway, it's just a thought. Let me know how wrong I am in the comments down below. Like I said before, please like this. If this was useful to you, hit that subscribe button. I'm going to keep working on these videos for you to just try to keep everything up to date and understand the news. Well, I appreciate it. Thanks.